Okay, carrying on. Okay, so thus in 1302, through unum sanctum, the Roman cult unlawfully claimed through trust the ownership of all the planet and all living things as either slaves or less than slaves, with things administered through the court of Rota. This court, claimed as the supreme court of all courts on the planet, was initially abolished in the 16th century, only to be returned in 1908 under Pope Pius X as a purely spiritual ecclesiastical court of 12 apostolic prothonotary spirits, implying the 12 apostles. Since then, this new purely spiritual court has remained in constant session, with the local courts using these powers to administer divine immortal spirits expressed in trust into flesh vessels as mere dead things. The system of global slavery and the treatment of the world as one large slave plantation was designed so there is no way out, as evidenced through the courts of the priests of Baal, known as the judges of most legal systems in the world. Even the most educated of men and women may remain tricked into believing that upon self-representation they can claim their common law rights as a means of defence, only to find the judge lawfully rejects any and all claims. As the first law of the courts is the UCC of slavery as introduced in 1933, the defendant is an employee or of a corporation and therefore automatically assumes the liability of any injury. Unless they can pay, they may be sent to prison. If such a trickster as the judge is challenged, they are permitted to escape to their chambers and call upon even greater power to return and magically establish a new court without telling the defendant they have now entered Admiralty Court, or the law of the sea in accordance with canon law of the Roman cult issued in 1983. Now the judge can impose grave penalties upon such an unresponsive defendant, including contempt of court and other punitive prison sentences, with the defendant having no rights unless they know canon law concerning juridic persons and establishing standing above being called a thing. So there you go, all these stories of frustration that people share about how they were ignored and so forth. Well, this is part of the reason why you're a thing. Right, so sadly, few people actually know the original meaning of thing as a judicial meeting or assembly, a matter brought before a court of law, a legal process, a charge brought, or a suit or cause pleaded before a court. This meaning is then used with devastating effect through the heretical concept of Pius X from 1908 to claim the dead apostles sit in permanent and open session as the 12 prothonotores of the sacred rota, as the highest supreme court on the planet. So when a man or woman receives a blue or yellow notice from a court issued through this unholy knowledge of canon law, by the time they come to court they are automatically a thing. When a man or woman seeks to defend themselves by seeking to speak before the judge, they automatically consent to being a thing. Thus, a judge with knowledge of such trickery can silence any man or woman by lawfully threatening contempt of court if the thing does not stop making noise. Indeed, it is the Roman cult canon law of 1983 that establishes all courts are oratories, with judges holding ecclesiastical powers as ordinaries and their chambers as chapels. Thus, the Bar Association around the world have assisted judges in learning of their new powers in order to counteract those men and women who continue to wake up to their status as slaves, but demonstrating how to remain in honour with such perverse law and ensure such terrorists are sent to prison for long sentences as a warning to others. If a judge so inclined to ensure an educated defendant is lawfully sent to prison or worse, he or she may run away for a third and final time to their chamber and invoke their most powerful standing as a rabbi of a Talmud court under the Talmudic laws of the false Israelites of the house of the 12 tribes of Manasseh. Now, even a judge in a nation that is against the death penalty may choose to impose a lawful sentence against any goy or gayu or goyim who dares injure an Israelite. So there we go, your average Joe Blow. If you dare to step up and claim any rights, you're looking at that. But we are moving beyond this now. This has all been foreclosed, so we need to stay positive that we're moving forward. However, while judges in the United States and other nations have started to be trained in the pre-imposition of Talmudic law, it is all at the hands of the false Manasseh, also known as the elite anti-Semitic parasites, also known as the Black Khazars and Venetian noble families. Ultimately, it is enough for judges, clerks and members of the bar to know that they hold our property in their Sesta KV trusts and that we are completely without effective rights until we challenge their fraud. Yet even when you challenge their fraud, many deny and outright lie on the record to deny they hold trustee and executor powers, with the case being a constructive trust and executor of the Sesta KV trust, from which powers are being drawn for the form of the court. Nearly finished now. I'm on my second last page. In 1534, prior to the first Sesta KV Act, Henry VIII declared the first Sesta KV type estate with the Act of Supremacy, which created the Crown Estate. In 1604, 70 years later, James I of England modified the estate of the Crown Union of Crowns. By the 18th century, the Crown was viewed as a company. However, by the start of the 19th century, around 1814, onwards upon the bankruptcy of the company, 1814, 1850, it became the fully private Crown Corporation controlled by European private banker families. Since 1581, there has been a second series of Sesta KV trusts, Sesta KV estates concerning the property of persons and rights which migrated to the United States for administration, including in 1651 the Act for the Settlement of Ireland, 1651-52, which introduced the concept of settlements, enemies of the state and restrictions of movement in states of emergency. And in 1861, the Emergency Powers Act, and in 1931, the Emergency Relief and Construction Act, and in 2001, the Patriot Act. Since 1591, there has been a third series of Sesta KV estates concerning the property of soul and ecclesiastical rights which migrated to the United States for administration, including in 1661 the Act of Settlement, and in 1871 the District of Columbia Act, and in 1941 the Lend-Lease Act. By 1815 and the bankruptcy of the Crown and Bank of England by the Rothschilds, for the first time the Sesta KV Trust of the United Kingdom became assets placed in private banks, effectively becoming private trusts administered by commissioners, guardians. From 1835 and the Wills Act, these private trusts have been also considered secret trusts whose existence does not need to be divulged. By 1917 and 1980, with the enactment of the Sedition Act and the Trading with the Enemy Act in the United States and through the United Kingdom, the citizens of the Commonwealth and the United States became effectively enemies of the state and aliens, which in turn converted the feared commissary private secret trusts to foreign situs private international trusts. Last page. This is now. Okay. In 1931, the Roman cult, also known as the Vatican, created the Bank for International Settlements for the control of claimed property of associated private central banks around the world. A Upon the deliberate bankruptcy of most countries, private central banks were installed as administrators. And the global KV trust system was implemented from 1933 onwards. Since 1933, when a child is born in a state or estate under inferior Roman law, 3 KVs are created upon certain presumptions specifically designed to deny the child forever any rights of real property, any rights as a free person, and any rights to be known as man and woman rather than a creature or animal by claiming and possessing their soul or spirit. Since 1933, upon a new child being born, the executors or administrators of the higher estate willingly and knowingly convey the beneficial entitlements of the child as beneficiary into the first KV trust in the form of a registry number by registering the name, therefore also creating the corporate person and denying the child any rights as an owner of real property. So when it's speaking about the corporate person, there are 2 of us in everything. There's 2 of me. If I walk into the bank, it's the straw man me, or the legal fiction me, or the artificial me that is really walking into the bank. And the bank created this legal fiction because it's a corporation, so it can only do business with a corporation, so it needs to make me into a corporation. So when I walk into the bank, it's me, the corporation, walking in with my name in capital letters. That's the only way it can do business with me. But because it didn't tell me it was making a second copy of me, once again, it's fraud. Each Sesta KV trust created since 1933 represents one of the 3 crowns representing the 3 claims of the property of the Roman cult, being real property, personal property, and ecclesiastical property, and the denial of any right to men and women other than those chosen as loyal members of the society and executors and administrators. The 3 Sesta KV trusts are the specific denial of rights of real property, personal property, and ecclesiastical property for most men and women corresponds exactly to the 3 forms of law available to the gala of the Bar Association courts. The first form of law is corporate commercial law, is effective because of the first Sesta KV trust. The second form of law is maritime and trust law, is effective because of the second Sesta KV trust. And the third form of law is Talmudic and Roman cult law, is effective because of the third trust. Baptism. The birth certificate issued under Roman law represents the modern equivalent to the settlement certificate of the 17th century and signifies the holder as a pauper and effectively a Roman slave. The birth certificate has no direct relationship to the private secret trusts controlled by the private banking network, nor can it be used to force the administration of a person or nation to divulge the existence of these secret trusts. As the Sesta KV trusts are created as physical secret trusts on multiple presumptions, including the ongoing bankruptcy of certain national estates, they remain the claimed private property of the Roman cult and therefore cannot be directly claimed or used. Right, I think I might leave it there because this session's about to end in 1 minute. Okay, we'll finish with any administrator or executor that refuses to immediately dissolve a Sesta KV trust upon a person establishing their status and competency is guilty of fraud and a fundamental breach of their fiduciary duties, requiring their immediate removal and punishment. So there we go. That is that history. Well, obviously there's lots and lots more, but that's a good little version of everything that you're buried beneath, all those trusts and acts. And in the next session I will speak about some of the experiences that I've had and how we need to repurpose what are these tools on our planet that have been built with our energy and are our resources to use. We don't need to keep paying for them. That's a ridiculous concept and just puts extreme stress on families, which is completely unnecessary. Okay, I'll leave it there for now. Thank you for listening.